Number 178, People of the State of New York versus Earl Jones. Good afternoon, counsel.
Good afternoon, Your Honors. Jody Ratner for Appellant Earl Jones. I'd like to request 2 minutes for rebuttal. The admission of the bystander's out-of-court statement was erroneous, where the record did not support the trial court's finding that it was an excited utterance or a present-sense impression. Mr. Jones was harmed since this statement, the bystander's accusation, was the evidence that influenced the jury to convict him of a burglary rather than a trespass.
Is the Confrontation Clause claim preserved?
I believe the Confrontation Clause claim is preserved because the prosecution raised it as an issue. Defense counsel noted that it related to hearsay, and that put it before the court's purview.
So maybe I misunderstood the record. I thought the judge asked counsel said, let me think about it, but then never came back.
Yes, and part of the preservation statute merely requires that it be within the court's purview, and I believe that it was in this case.
But don't you have to make a protest? Was that a protest? Would you say that was a protest by saying, let me think about it?
It doesn't always have to be a protest. It can be something that the court understands is an issue and then either rejects either implicitly or explicitly.
So is that your argument also for preservation on the excited utterance?
Not at all. So far as preservation for excited utterance and the present sense impression, defense counsel put forth before the court many gaps in the evidence as to what was lacking from the prosecutor's presentation or application and why the prosecutor didn't meet his burden.
So what would have been necessary, counsel, in addition? How to create the foundation? What'd they miss?
They missed quite a bit. As for excited utterance, there was no indication whatsoever that the bystander was startled or that this was, that she continued to be under the stress of a startling event. She merely stated, did you see him try to get in the back of the truck? She could have been a good citizen who was alerting a police officer to something that she believed she saw. This is completely unlike most of the cases decided by this court in which a victim especially, but even a bystander observes an event that is either violent or so shocking. This is just not of that nature. This is somebody standing who happens to see possibly a tug on the back of a truck. It could have been a tug. He could have just been standing there, and being that he wasn't in a FedEx uniform, he was carrying what looked to be like some sort of tool and a bag. She may have even just come to the conclusion that he had nefarious purposes. But we don't know because that burden was not made out by the people when they made their application to admit this as hearsay.
What about the present sense impression? Does it have to be exactly contemporaneous that while he's standing right there, she makes the statement, or can it be, as here apparently, as I see the record, within perhaps seconds of when it happened?
The time frame isn't the important factor. What's the important factor is whether it's contemporaneous, which here the event had ended. So even though
he was still walking away, wasn't he?
He was walking away,
within
but
sight?
But the crime that she believes she saw had ended. He was departing. The event was no longer.
Right, you have to, your present sense impression, your remark has to be while the crime is occurring?
While the crime is occurring or immediately thereafter. This
Well,
was
why
not.
isn't this immediately thereafter? And by the way, where is the officer at that time? If it's at the moment that I think you're suggesting, which is as it's happening or just as he's turned his back, where is the officer? Does she have the opportunity to actually say something to someone at that point?
What we know is that the officer is arriving towards the back at some point during this. By the time the officer reaches her, Mr. Jones is halfway up the block. So what she could be saying is what she saw. In fact, her words lead to impression that she is talking about a past impression. She doesn't say, do you see him doing that? She says, did you see him doing that? Within that short time frame, she could have leapt to a conclusion about what she thought she saw and not necessarily what she
Well,
was
if
perceiving.
it's immediately thereafter, it would also use the past tense. So when we say thereafter, that assumes that it's happened. So that in itself isn't enough to.
It also needs to be what she perceives, and what she
Well,
perceives
isn't the
is...
test, though, isn't the test whether or not the person making the statement had time to reflect on the statement? Isn't that, would you
It is,
agree
Your
with
Honor,
that?
and she could have had time to reflect. Yes.
So you think here, your basic argument here, the factual structure is that she had time for reflection.
Correct.
I see.
But
And
isn't
it's
that a
also-
factual question then? I mean, it's, as I recall the testimony, I think the officer sees the legs under the truck, so he's close enough to see that. So the judge is listening to this and hearing that testimony. He sees the legs behind the truck. I think it's the officer then goes around, the defendant comes around the other way. So why would we substitute our assessment of what the time frame is for what the assessment that was made at the trial court?
Well, the time frame and the corroboration, which is what Your Honor is also getting to.
But it
is-
goes to time frame since he was close enough
Right.
to see it.
But time frame is only one factor. The other factors that need to be determined are whether this was corroborated. We don't know what she saw. The officer doesn't know what she saw. The officer only
Then he
knows
could
that Mr.
testify to it himself. I mean, the point of getting this in is it's an excited utterance. He wasn't there, she's saying it. So I don't understand the relevance of that argument to how it comes in or not.
Well, I was referring to the present sense impression and corroboration, not to the excited utterance.
Okay.
Again, I don't think this was an excited utterance in any sense of the word. She merely
Present
saw
sense
something.
impression, he doesn't see it.
He doesn't.
But it's immediately thereafter as he comes around the truck.
Right, but it needs to be corroborated. It needs to have some indication of corroborated. In Vasquez, this court said that there needs to be independent verification of the declarant's description of the unfolding events. The officer here does not know what those unfolding events are.
Sees him in the cab, right? The officer sees
Right.
him in the cab. Then he sees his legs in the middle of the back of the truck, as I understand it. So it doesn't have to be he sees the same thing. It has to be some corroboration of what she saw.
Right, and there was none. He saw a trespass. He saw a trespass
But
in
he
the cab.
sees him standing
and then
at the
he
back
sees
of the
him
truck.
Right, and that does not corroborate that Mr. Jones was trying to get into the truck. All it
He also
corroborates is
sees-
that he was standing there.
He doesn't just see a trespass. He doesn't just see him go into the truck and, sit down at the driver's wheel or something. He sees him go into the truck and he has head movements that look like he's looking around for something.
That's a
it's not-
trespass. That's not an intent to
It
do
is,
anything.
but when it's coupled with everything else that he sees and he knows, and then he goes to the back and then he stops there, he doesn't just walk around the back and keep going, he stops for some period of time. All of those things, and what he did before he got there, all of those things
Right,
put
but we need
together.
corroboration
Well, the
of,
problem is, I think, maybe the way you're viewing corroboration. I don't think corroboration requires a witness that saw the exact same things that this witness is testifying about. What it requires, and I think the case laws show, is some evidence that at least, part of what's been testified to can be verified by some independent observation or independent evidence. And here, we have that with the evidence of a trespass.
I respectfully disagree. In the case of
You're saying
Brown,
that, let me just finish then, so I'm clear. You're saying that it requires someone to see the same things that I saw to corroborate.
I'm not saying that. What I'm saying is it depends on the facts of the case.
Okay.
In the case of Brown, somebody from across the street called 911. They said that they saw a break-in. They described two men on the scene. The police officers showed up. They saw the two men exactly as described by the witness, or by the 911 caller, leaving a restaurant through a broken glass door. They didn't see the exact thing. They didn't see them go in, but they saw them come out, and they saw all the indications that what the caller had reported was what had happened.
But we would have
In
to
the-
say then, as a matter of law, this wasn't corroboration. Because you're saying it depends on the factual circumstances of the case. But we would have to say here, as a matter of law, I think Judge Stein was describing, he sees him go to this building as a box cutter, he has a bag, he goes in the truck, he's going up and down in the truck, he sees his legs in the back of the, and that's not enough as a matter of law.
As a matter of law, the facts that were presented by the people before the trial court were not sufficient to make out their burden, yes.
Thank
that
you,
is
counsel. And if you care to address your legal sufficiency argument, you'll have that opportunity during rebuttal time. Counsel?
Good afternoon, Your Honors. My name is Jared Walkowitz, and I represent the people in this case.
What proof is there in this record of, that would support a finding that this was an excited utterance?
Your Honor, as this court has said, above all, the decisive factor for an excited utterance is whether the surrounding circumstances reasonably justify the conclusion that the remark was not made under the impetus.
Don't we need something about her demeanor, her, some indication of what her state of mind is beyond the mere circumstances, or maybe that she had some connection to the truck or something?
You do have that here. You don't have.
What do we have?
You don't have tone. That's what they seem to get at, or psychological conditions. But what you do have here is the witness's actions, which display excitement and stress.
What were those actions?
She waits there because, as you stated before, the defendant is walking away from the scene. She stays there. She waits for the officer. She says to the officer, "Did you see that he tried to get into the back of the truck?" Then she says, "Are you going to get him?" So it shows that she has some sort of excitement or stress based upon this event, and the surrounding circumstances here show that.
How do you know that, based on the description of this woman from the officer, a little person, about 50 years old, do you think she's using the same tone that you just did when you made that argument?
No,
Is that what you?
but the words use the same tone. I mean, it has to be sufficiently startling or powerful enough. It doesn't, as they write in their brief, it doesn't have to be a murder. It doesn't have to be it doesn't have to be a stabbing. It could just be, Your Honor, some event that causes you to stop that reflective process. That's what your cases tell us.
I don't know. I mean, if she came running around the back of the truck and ran up to the officer and said the same thing, to me that would be some more of an indication. But you say she's standing there, so she just observed whatever she observed, and she's standing there. And then the police officer comes back and she said, "Did you see what he just did? Are you going to get him?" I mean, if you think of it that way,
Right.
It could be a complete absence of excitement.
Well, we provided to the court, I just want to get back to preservation just for that one purpose. We provided to the court an offer, and the court accepted that offer, and we went forward. We believe that was excitement and stress to satisfy your standards. If they wanted more, if they wanted that tone, if they wanted that psychological condition, one, they were free to ask, and two, they were free to protest to the judge about that.
Doesn't that get, this is a taffy pull that seems to happen a lot. What's wrong with the judge not being satisfied, or being satisfied?
I'm sorry?
What's wrong with a judge not being satisfied with your proffer, or being satisfied, and that preserving the issue?
Well, the thing is, the problem, Your Honor, is in New York, there's a statute that says, here, what you need is them to specifically bring up the issue that they're raising on appeal, or in response to a protest by a party, the court must expressly decide that issue. Their issue on appeal is that they weren't under the stress of the startling event, that this wasn't a startling event, and that we didn't know the tone or the psychological condition of the declarant at the time.
But given the nature of this exception, isn't the whole point that you got to be excited?
Well, yes.
So if the court allows it in, isn't that the court deciding, I think it was excited?
But they're not protesting what they're arguing on appeal. If you read their brief, their reply brief,
Which
they
we
would,
have.
Of course, I'm saying just as a general matter, it would obliterate New York's preservation requirement, because their theory is, what you have is anytime the people go through the elements of a certain crime or a certain legal standard, if they just say, "I object," they've preserved it.
Yes, they have.
And That's not the law, though, Your Honor.
Well, maybe it is, because it seems to me the judge is not a cipher. I mean, the judge doesn't just sit there and say, well, I've heard from the DA, and because they said that this woman was excited, even though she called 3 days later and said, I really should have brought this up at the time, but I wanted to tell you that I saw this man in the truck. I find that to be an excited utterance. What do you want the defense to say, Judge, how stupid can you get? No, the judge has to have something to do with this, and in this case did, and made a decision that, as we're arguing, on the merits is not a bad one. But to say that they cannot raise in front of an appellate court an excited utterance when they objected, and you said it's an excited utterance, and the judge said, I'm overruling the objection that that's not preserved. I'm missing it, and I do this a lot. I miss it a lot because I don't understand how many times you got to go to a judge and say, Judge, just so we're clear on why I think you're wrong, I want to spell out some more. There are judges that say, I want no speaking objections.
Well, Your Honor, that would be a case, but that wasn't this case.
But let me ask you this, don't you think you have enough in front of you to argue on the merits of this?
Absolutely.
Okay, I guess
So
we're good.
I will do that as well, as I was doing before.
Counsel, just to go
sure.
back, go off of that topic for a second, to go back to something your opponent, I think, said early on, is this harmless error? If it's error?
It's not error, but if it was error, it would be harmless error, Your Honor, because even if you extracted that statement from the case, there's still plenty of evidence. He looked both ways and looked into the van to the cab for 5 seconds. His head bopped up and down, and he looked around. That's all that statement. He had a tile cutter. He had a duffel bag, which just added to the proof that he was seeking to, burglarize or take stolen items for the intent to. So even if you extracted that particular piece of evidence, there would be plenty of evidence.
All of that except the duffel bag and the tile cutter are based upon the officer's testimony, though, right?
Yes. Everything in the case besides the declarant statement and the two items are based on the officer's testimony. But I want to go back to just one thing my opponent said about the corroboration requirement. This court specifically, and I know Judge Fahey was getting to this, in Brown, made clear that they rejected the equally precipient witness test, that there was 3 options in Brown. One was the prosecutor in that case argued, well, there should be no, because of lack of time, there should be no corroboration whatsoever. 2, there was an equally precipient one where they'd have someone who saw exactly what the witness saw. And then the third option, and this court described it as the middle ground, was that we would take other evidence as corroboration. And here, it was clearly other evidence. Not only does he go into the truck, in the front compartment of the same truck that he's accused of going to the back of, he also is seen by the officer, as Your Honor was saying before, his feet are going to the back. The officer sees him through the side view mirror with his feet going to the back. The officer then sees him at the back for a few seconds, then sees him walking away from the back. So there was an ample amount of corroboration for this particular case.
Is there an argument, I don't know if you made it, that neither one of these make any difference, whether it's an excited utterance or present sense impression? It was simply an officer investigating and somebody said, yeah, I saw the guy in the truck.
Well, I mean,
It doesn't go to the truth of it. It just says, based on that, I did something else.
I mean, we offered it for the truth, so to the extent that we formed a legal
Didn't
foundation.
preserve that argument?
Right, well, we offered it for the truth. And the one thing I do want to get back to on preservation, we could argue about excited utterance as we were doing before, but they never used the word present sense impression.
You did, right? The people did.
The people did. But again, if they didn't even say, they didn't say corroboration. They didn't say, I mean, the part that if I could just get back to that argument, I know we went on to something else about the preservation, because I do think this is an important point. The point is not only is it's the judge is the one we're judging in some ways, right? We're asking that judge, did you make an error? And doesn't the defense owe it to the judge to make that argument in front of it, to give the judge to cure the error? If they would have said to us on the excited utterance, people, I didn't hear anything about the tone. We could have asked the officer, what was her tone?
Well,
Maybe it would have
they
helped.
did say there's nothing here at all. They said, all we know is that it was a woman, we don't know if there was any contact, and then they said, and there was nothing else about her that we know.
But they didn't say anything about excitement. They were talking about the foundation, about her, they said first her exact words. They were talking about her words at first.
These aren't hard. Judges do them all the time. And for you to say, well, they got to say tone so that we can fix the error that we made in offering this is, there's strategic reasons why you do stuff.
Well, the only thing, the strategic reason isn't to get a reversal. The strategic reason is, should this be admitted or not?
Right.
And the point was, if they're going to argue it shouldn't be admitted based upon the declarant's condition.
You say it's not an excited utterance. I don't think they have to say and pull out Richardson or.
But the point of the preservation, my final thing, Your Honor, I'll let it go after this.
Me too.
The point of preservation requirement is to give the judge, the people, whoever it is, an opportunity to cure. And we weren't given that opportunity here, and we were disadvantaged by that, and that's why it's not preserved. Thank you.
Thank you, counsel. Counsel?
Before I'd like get to legal sufficiency, I'd like to just finish one moment with the present sense impression merits analysis. The corroboration, again, what could have happened behind the truck? I can think of at least 3 scenarios. My client stood there and looked at the lock.
But is
He
that to
tugged.
test that there's no other thing that could possibly have happened but what she said happened?
Well, she said, get into the truck. We don't know what that means. She could have been making an assumption based on him standing there with a tile cutter and a duffel bag. She could have assumed that. He could have tugged on it, or he could have taken that tool and tried to rip it off. Between that whole range of things, we don't know.
Isn't that a subject for cross-examination?
That is why we would have liked to have had her there,
Well,
which
no,
is
I
why.
mean, you could cross-examine the police officer on that, right?
All the police officer knows is what the bystander told him, which is the whole problem. Because he didn't see it himself, there was no corroboration. All he knows is that there were 2 legs there. His viewing of those legs didn't corroborate what she said. So no matter what question was asked of him, there was no corroboration.
So
of
does
that
the police officer's observations count for nothing in verifying or corroborating?
I wouldn't say that they count for nothing, but I don't think that they were corroborative in this situation here, merely because he saw legs behind the truck. Going to legal sufficiency.
Sorry, but before you do that.
Yes.
But your point is the only observation of the officer that counts is seeing the legs behind the truck and the pausing of the legs and then the movement, as opposed to everything that went on before?
That was the moment that she was talking about. That is the moment that needed to be corroborated, yes. And in addition, one other thing before I get off present sense impression is the sense that she needed to perceive something is part of a present sense impression.
Counsel, I hate to beat that preservation horse to death, but I read that colloquy back and forth. I did not see anything from defense counsel on present sense impression.
I can review some of the things that I believe go to that. Counsel stated that it wasn't corroborated when he said that the police officer didn't testify that he saw Mr. Jones trying to get in. He said he didn't know why she was surmising what she did. He didn't know where she was standing. All of those things go to what she was perceiving, how she was perceiving it, what exactly she saw, all of which were gaps in the people's presentation of their
Take 30 seconds
application.
on sufficiency? 'Cause the
On
red light's on.
sufficiency, all we have here is somebody walking around holding a bag in one hand, a tile cutter in another. He trespassed in the building, the jury got it right there. All we know insofar as the FedEx truck is that he trespassed in the front and then he walked around the back. A bystander thought he tried to get in, but this doesn't rise to the level of an intent to steal anything in the truck. When he was in the cab of the truck.
Intent can be made up from circumstantial evidence,
It
right?
can be, but you need more than somebody wandering around, poking in here, poking in there. He tugged at the first door of the first building. He wasn't even indicted for a burglary in that building, and for the second building, he was in the building. He came out of the building. The officer saw him, came out. It was a trespass, and same with the FedEx truck. When he was inside the cab, he didn't turn around and try to get into the door that way. Thank you, Your Honor.
Thank you, counsel.